DEI under fire. Schools caught in legal crossfire over diversity programs, the nation's K-12 school districts are navigating a chaotic legal landscape as the federal government escalates its opposition to diversity, equity, and inclusion (DEI) initiatives. A series of contradictory orders, lawsuits, and court rulings have left educators scrambling to determine which policies are legal, which federal funding streams are at risk, and how to comply with rapidly shifting directives. Federal pressure and policy reversals the conflict ignited with a Department of Education letter in April demanding schools certify their compliance with federal laws or risk losing Title VI funding. In response, districts in Decatur, Georgia, and Haldane, New York, hastily rescinded or suspended DEI policies only to reinstate them days later when federal judges blocked the administration from withholding funds. This whiplash effect underscores the broader instability. It's a really complicated landscape right now, explains Ray Lee, Policy Counsel for Education Equity at the Legal Defense Fund. He stresses that DEI policies themselves aren't illegal, despite the aggressive federal stance. The real issue is a deliberate effort to weaponize compliance procedures and create confusion. The false dichotomy of DEI, the debate, often frames DEI as a simple binary: either a school has a policy or it doesn't. But experts like Carlos Hoyt, a DEI trainer, argue that this is a false choice. Even policies that prioritize certain groups over others represent a form of DEI, albeit an exclusionary one. A truly inclusive approach, he says, would be broader and more equitable. Panic and backtracking in Decatur, officials admitted to making a wrong decision when they initially cut equity policies, citing fear of federal retaliation. The board reversed course after court rulings, but not before police forcibly removed a parent who protested the initial cuts. The district gets $3.2 million in federal funding, primarily for special education, raising the stakes for compliance. The legal ambiguity extends beyond the April letter. A February Dear Colleague letter from the Department of Education attempted to clarify non-discrimination obligations, specifically mentioning alleged discrimination against white and Asian students. A federal judge quickly blocked enforcement of this directive as well. Despite the confusion, some states, like Massachusetts, doubled down on DEI, with Governor Maura Healey issuing joint guidance to schools to continue fostering diversity. However, the federal government's ongoing efforts to target DEI and gender-based policies have already led to funding cuts for magnet schools in New York City, Chicago, and Fairfax, Virginia. Tracking the chaos, tracking the legal battles is essential for school officials. Resources like Lawfare's Litigation Tracker and the Brookings Institution's Tracker monitor active cases challenging federal actions. The Department of Justice has also joined the campaign, issuing guidance that recipients of federal funding must not engage in unlawful discrimination. The uncertain future, despite legal challenges, the underlying tension remains. DEI training continues in some schools, like those served by DEI trainer Carlos Hoyt, but the broader uncertainty persists. As Hoyt puts it, "I think we're stuck with this uncertainty for a while." The partisan battle over DEI funding and policies is likely to continue, leaving school districts caught in the crossfire. In conclusion, the current legal landscape surrounding DEI in K-12 education is highly unstable and politically charged. Schools face pressure from the federal government while simultaneously battling lawsuits that block aggressive enforcement measures. The outcome remains uncertain, but districts must navigate this chaos carefully to protect their funding and maintain their policies.